Hi, this is Lee from the Law School Toolbox and the Bar Exam Toolbox. Welcome back to the Listen and Learn series. Today, we will be discussing duties to the tribunal, a subtopic of professional responsibility. Entering the legal profession means you must abide by certain ethical guidelines. Each jurisdiction has its own set of ethical guidelines, many of which are modeled after the model rules of professional conduct. The purpose of these guidelines is to protect the public, maintain trust in the legal profession, and ensure the administration of justice. In order to achieve these goals, it is important that a lawyer is always truthful in their statements to others, including the tribunal. Because of how important truth-telling is in the legal profession, the model rules of professional conduct have many rules requiring this of lawyers in different settings. Rule 4.1 governs truthfulness in statements to others, and Rule 7.1 requires truthfulness in communicating a lawyer's services. In this episode, though, we are going to focus on Rule 3.3. Model Rule of Professional Conduct 3.3, known as Candor toward the Tribunal, governs truth-telling to the tribunal. A tribunal is a court, arbitrator, administrative agency, or any other body acting in an adjudicative capacity. Essentially, this rule boils down to a lawyer having a duty not to knowingly mislead the tribunal. As with anything in the law, though, it is never that simple. In this episode, we will break down Rule 3.3, talk about all of its nuances and parts, so you feel prepared going into class, a final exam, the MPRE, or the bar exam. The first piece of Rule 3.3 is 3.3a. This rule explains that a lawyer must always be truthful when it comes to making statements and presenting evidence to a court. Rule 3.3a says a lawyer shall not knowingly make or fail to correct false statements of material fact or law, fail to disclose controlling legal authority adverse to the client, or offer false evidence. So let's go through each of these one by one. First, a lawyer shall not knowingly make or fail to correct false statements of material fact or law. This means a lawyer cannot know they are making a false statement of material fact or law to the tribunal. Additionally, if the lawyer later finds out they made a false statement of material fact or law to the tribunal, they need to correct it. A material fact or law is something that influences the outcome of a case. As an example, in a divorce proceeding, if the lawyer says the husband has blue shoes when really he has black shoes, that would not be considered a material fact, because the color of his shoes in no way would determine the outcome of the case. But if the lawyer knowingly misstates the husband's relationship with a woman he had an affair with, that would be considered a material fact. There is a key difference here between impartiality and lying. A lawyer is not required by the rule to be impartial. A lawyer is expected to present a case that is partial toward their client. However, in doing so, the lawyer cannot mislead the tribunal by statements the lawyer knows are false. The second piece of Rule 3.3a states that a lawyer shall not knowingly fail to disclose controlling legal authority that is adverse to their own client and not disclosed by opposing counsel. To better understand this duty, imagine that you are an attorney representing a client in a battery case. The primary question of the case is whether or not your client had the intent to cause contact with Joe because your client was really trying to cause contact with Sam. In your research for this case, you find Talmadge v. Smith, a case out of Michigan, 1984. Talmadge v. Smith teaches you the doctrine of transferred intent, that so long as the requisite intent was formed against one person in a battery case, it can transfer to another person who is actually harmed. This case law is clearly adverse to your client because it establishes that your client can still be liable for battery even though they meant to hit someone else. If opposing counsel fails to disclose Talmadge v. Smith to the court and you also failed to disclose it, you would be in violation of Rule 3.3. A few important pieces of this rule I want to make clear. The legal authority here has to be both controlling and primary. A law review article from another state does not fall under this rule because a law review article is secondary authority, not primary authority. Similarly, if you were trying a case in New York, you would not be required to disclose Talmadge versus Smith because that case is from Michigan and as a result not controlling. The legal authority also has to be directly adverse. A case that is only closely related to the issue does not need to be disclosed. If your case only dealt with battery and not the sub-issue of transferred intent, you would not need to disclose Talmadge versus Smith, even though Talmadge versus Smith also dealt with a battery. The two situations would not be directly adverse. Additionally, this rule only applies to controlling legal authority. The lawyer knowingly fails to disclose. Rule 3.3 does not subject a lawyer to discipline for inadvertently overlooking a case, but this could raise questions about the lawyer's competence under Rule 1.1. Finally, the duty to disclose controlling adverse authority does not arise until opposing counsel fails to cite the authority. If opposing counsel raises Talmadge versus Smith, you would be under no obligation to also disclose that authority to the court. The third piece of Rule 3.3a states that a lawyer shall not knowingly offer evidence that the lawyer knows to be false. The specific duties the lawyer owes to the tribunal here differ based on whether the case is civil or criminal, and whether the false evidence has already been offered or the lawyer just believes it is about to be offered. In a civil case where the lawyer offered material evidence through a client or witness and later realizes the evidence was false, the lawyer must take reasonable remedial measures to remedy the situation, which could include disclosure to the tribunal. In a civil case where the lawyer knows the client or witness intends to testify falsely or knows the client or witness wants the lawyer to introduce false evidence, the lawyer must similarly take remedial measures. The lawyer should first attempt to persuade the client not to testify falsely. After talking with the client, if the lawyer is satisfied that the client will tell the truth, the lawyer can continue with representation as normal. However, if the lawyer believes the client will still testify falsely, the lawyer must refuse to offer the evidence. A lawyer does this by refraining from asking questions that elicit false testimony or even refusing to let the client testify. If the client still testifies falsely, the lawyer should seek to withdraw, because by not withdrawing, the lawyer would be participating in the perjury. If withdrawal is not granted, the lawyer must disclose the false testimony to the tribunal, even if that information is protected by the duty of confidentiality in Rule 1.6. To help you better understand this rule, imagine that you are representing a client in a suit against a grocery store. Your client claims there was spilled milk in one of the aisles. The grocery store workers failed to clean it up, and as a result, your client slipped and fell, a classic case of negligence. Some days before trial is set to begin, your client confides in you that they were the one who spilled the milk, and they purposefully slipped on it to get a big payday. You were planning on having your client testify, but now you are not sure what to do because you now have knowledge your client plans to offer false evidence in a civil case. Your job is to persuade your client to tell the truth. If you believe your client will still lie, you have the choice to either let them testify or refuse to let them testify. If you decide to still let them testify, you should refrain from asking them any question that will allow them to lie. If you believe your client will tell the truth, you can continue with the representation as normal and have them testify. In the criminal context, the requirements of the rule are a little different because criminal defendants have a constitutional right under the Sixth Amendment to testify on their own behalf. This means if a lawyer knows their criminal client is going to testify falsely, the lawyer should try to persuade the client to tell the truth, but the lawyer cannot stop the client from testifying. If the defendant does offer false testimony, the attorney should allow the defendant to give what is called a narrative statement. This is where the defendant presents their testimony without any participation from the attorney. The lawyer should also seek to withdraw from the case to avoid assisting the client in committing perjury. The next piece of Rule 3.3 is 3.3b, which deals with protecting the tribunal against criminal or fraudulent conduct, such as bribing, intimidating, or unlawfully communicating with a witness or juror, or unlawfully destroying evidence. If the lawyer knows that conduct that will undermine the integrity of the adjudicative process will take place, the lawyer must take reasonable remedial measures. These remedial measures are the same as we discussed with Rule 3.3a. A lawyer must try to persuade that person, withdraw from representation, and/or disclose the conduct to the tribunal. The duty to remedy perjury and protect the tribunal do not last forever. Rather, the duties in Rule 3.3a and Rule 3.3b only last until the proceedings are concluded. The proceedings are concluded when the court enters final judgment, and there are no more opportunities for appeal. After this point, if a lawyer finds out their client lied, the lawyer is under no obligation to remedy it. So let's try out a couple of hypotheticals to see how well you understand Rule 3.3. This first one is adapted from the February 2024 California bar exam. Amber represents Davos, a professional athlete, through a valid written retainer agreement. Davos was sued by Karen for allegedly assaulting Karen at a restaurant. Amber asked Davos to gift her season tickets to Davos's games if she prevailed in the case. At trial, opposing counsel presented the restaurant's surveillance videotape as evidence, which showed the assault, along with a video surveillance expert who identified Davos in the video. Amber presented the testimony of Eileen, an experienced video technician, who testified that, in her opinion, there was no assault based on the poor quality of the video. When Amber and Eileen had previously watched the video together, they both agreed that the video showed strong evidence of the assault. Once Eileen agreed to change her opinion and testify that there was no assault based on the quality of the video, Amber agreed to pay Eileen $500 per hour for testifying at the trial. What ethical violations, if any, has Amber committed? So let's ignore any other ethical violations going on here and just focus on Rule 3.3. Well, what do you think? We have a situation where Amber, the lawyer, devised a plan for Eileen, a witness, to lie on the stand, and then allowed Eileen to lie on the stand. Rule 3.3 is triggered because Amber knew Eileen was going to make false statements while testifying and still let Eileen testify. This is a pretty blatant violation of Rule 3.3a. According to Rule 3.3a, Amber should have never let Eileen testify that there was no assault based on the poor quality of the video. Instead of counseling Eileen to lie, Amber should have counseled Eileen to tell the truth. Because in this situation, Eileen already gave the false testimony, if we focus just on Rule 3.3, Amber will likely need to withdraw from her representation and disclose the matter to the court. So let's try one more that is a bit more complicated. This one is adapted from the February 2018 California bar exam. Austin recently sold a warehouse to Beverly. The warehouse roof is made of a synthetic material called top tile. During negotiations, Beverly asked if the roof was in good condition, and Austin replied, "I've never had a problem with it." In fact, the manufacturer of top tile notified Austin last year that the warehouse roof would soon develop leaks. After Beverly bought the warehouse, the roof immediately started leaking. Beverly hired Lou, an experienced trial lawyer, and executed a valid retainer agreement. Beverly then sued Austin for rescission of the warehouse sale contract on the basis of misrepresentation and non-disclosure. At trial, Lou offered the expert testimony of Dr. Crest, a chemical engineer who had testified in other litigation concerning top tile roofs. Lou knew that Dr. Crest had previously testified that top tile roofs always last at least 5 years. Lou also knew from the manufacturer's specifications that top tile roofs seemed to last indefinitely, but not in some climates. On cross-examination, Dr. Crest testified that top tile roofs never last 5 years, and that climate is not a factor. Top tile roofs fail within 5 years everywhere in the world. During closing argument, Lou repeated Dr. Crest's statements. So what, if any, ethical violations has Lou committed? All right, what do you think? Do you see any Rule 3.3 violations? Well, there's a lot going on in this fact pattern, so let's break it down together. The first potential Rule 3.3 violation going on in these facts is that Lou failed to offer the fact that top tile roofs deteriorate in certain climates. You might be thinking this is a clear Rule 3.3 violation because Lou did not disclose to the tribunal adverse facts to her client. Remember, though, that Rule 3.3a does not say a lawyer must disclose adverse facts to the tribunal. The rule says a lawyer must disclose adverse controlling legal authority to the tribunal. This means Lou was under no obligation to disclose to the tribunal that top tile roofs deteriorate in certain climates. The next potential Rule 3.3 violation is that Dr. Crest gave false testimony. He previously testified that top tile roofs always last 5 years, but in the current case testified that they never last 5 years. Dr. Crest also went against the manufacturer's specifications by claiming climate does not impact how long top tile roofs will last. The question would become whether or not Lou knew Dr. Crest was going to give this false testimony. If Lou knew Dr. Crest was going to give false testimony before he gave it, Lou would have been required to attempt to persuade Dr. Crest not to commit perjury on the stand. If Lou did not do this, she would have violated Rule 3.3. If Lou did not know Dr. Crest was going to testify falsely, but now knows he did, Lou is obligated to remedy the situation. Regardless, now that Dr. Crest did give false testimony, Lou is obligated to take remedial measures, which may include disclosure to the tribunal. If Lou does not take these remedial measures, Lou would be in violation of Rule 3.3. The final potential Rule 3.3 violation present in the facts is that Lou ratified what Dr. Crest said in her closing argument. Remember that Rule 3.3a states a lawyer shall not knowingly make or fail to correct false statements of material fact or law. The facts tell us that Lou knew what Dr. Crest said was false, but repeated it anyway in her closing argument. The quality of top tile roofs is a material fact because whether or not the roof will deteriorate in certain climates and how long it is meant to last will impact the outcome of the case. By ratifying a material fact Lou knew was false to the tribunal, Lou violated Rule 3.3. Now, before we end, let's do a recap of what we talked about. The model rules of professional conduct provide ethical standards to protect the public, maintain trust in the legal profession, and ensure the administration of justice. Among the many ethical standards a lawyer must comply with is their duty to the tribunal, or Rule 3.3. According to Rule 3.3, a lawyer shall not knowingly make or fail to correct false statements of material fact or law, fail to disclose controlling legal authority adverse to the client, or offer false evidence. Always remember, whether you are in law school, studying for an exam, or entering the legal profession, to always be truthful in your statements to others, including the tribunal. Thank you so much for watching. Be sure to give us a like, leave us a comment, and subscribe so you don't miss any future content. Also, learn more about us at lawschooltoolbox.com and barexamtoolbox.com.